Let me get started. So today I've got a guest. I know I don't do a whole lot of guests on the program, and part of it is sorting out logistics and that kind of stuff. For those who are unfamiliar, I do the show from the Cattaraugus territory of the Seneca Nation. I am not Seneca. I'm Mohawk. My wife is Oneida, and we live in Seneca territory. So I got three of the five or three of the six nations, kind of taken care of just in my very existence here. So I connect the show up to WBAI in New York City and into WPFW in Washington D.C. That's how we do the program. Um, but you know, so I'm connecting on territory, and I oftentimes have to make people aware we don't have the best internet technology here, so we're always a little bit of at a little bit of a disadvantage. But we've been able to pull it off. I'm working to improve that, and but let me get right to my guest. So my guest is um, Eve Reyes Aguirre. Aguirre. I'm sorry. I asked you how to pronounce. Did I get Aguirre? Okay.
Aguirre.
Aguirre. Okay. Um, I'm gonna let Eve explain more of what she does and the work that she does in Arizona, and also an event that she's about to leave to go attend and participate in Atlanta. So let me just start there, and I'll let you explain a little bit about the work that you do there and what you plan to do this weekend.
Thank you, John. First, let me just say, Amishpansinko, no one yolken, otoka oselosochi, iwan ikanawat. My name is Ivre Zakiri. I just introduced myself in my traditional language. I'm Iskaloteca Mexica, also known as Aztec. And I reside here in Phoenix, Arizona, in Autumn Territory. And I work for an organization that serves as an embassy for Indigenous peoples called Dona Tierra. And so I've been part of the organization for about 30 years now, and our work expands around Indigenous rights and Indigenous advocacy internationally, uh, nationally, locally, very communal. And our nonprofit organization has been around for 40 years, serving our relatives, not just both here in the North and the South, but also globally and through the international work that we do at the UN. So I'm really honored to be a part of the show. I'm really excited about the work that we have coming up in regards to the upcoming so-called 4th of July, 250th year anniversary of this colonial country that has been imposed on us. And so we're really excited to kind of have a counter event and really put some truth behind the history of what this 250 years means, not just for this so-called country called America, but also what it means to the people who have been here since time immemorial, the indigenous peoples of this continent. Who have experienced, basically genocide. That's what we were going to be focusing on is the truth and the history of 250 years of battling against genocide.
Well, and again, there's a lot of irony associated with celebrating the Fourth of July as America's birthday. Um, Obviously, our circumstances run much farther back than 250 years, but it's also kind of ironic that telling the truth ends up being the counter narrative. I mean, the idea that by just telling the truth about not only the Declaration of Independence, and for those who are watching the show as a video, you see that I'm wearing again, and I've been doing it for the last probably 4 weeks anyway, one version or another of my Merciless Indian Savages T-shirts, and in this case, tank top. It's a hot day here up in New York. Um, and the reason I wear the shirt is because in the Declaration of Independence, the colonists via through Thomas Jefferson's writing of this declaration file a bunch of charges against the King of England, King George. And as you read those charges, and unfortunately, most people never read the Declaration of Independence, so they're completely unaware of what they're actually celebrating because it's the declaration, it's the document, and the signing of that document that is actually the anniversary on the 4th of July. So but if you read it, you realize there's an ever increasing level of discontent offered in those charges against the king. And the last charge, the very last charge he makes against the King of England is that he has incited insurrection amongst the colonists. First off, causing dissension within the colonies themselves. Then he said he's brought on to their frontier the merciless Indian savages whose manner of warfare is a undistinguished destruction of all ages, sexes, and conditions. That's the final, and that is the essentially their final and most vehement charge that they've expressed against the king. So, as I've mentioned over the last several weeks, we are the only ones specifically cited in the Declaration of Independence. To be cited specifically. I mean, they mentioned the King of England, and obviously, in the charges are against him, but no other peoples, no, not women, not children, not other immigrants, not Englishmen, not Frenchmen, not nobody's mentioned specifically except for Native people, and it's done in the most derogatory fashion. And it's not just derogatory because they call us merciless Indian savages, but I have to note the fact that they are suggesting that we have an undistinguished destruction of all ages, sexes, and conditions. When you look at the history of the United States, beginning with its at its birth, because Native people were being slaughtered by colonists. I mean, there's a prime example is a massacre they call the Ganadin or massacre. It was out near Pittsburgh, what is known as Pittsburgh now, and or the Moravian massacre. It's also called because these were all Christianized Native people. These were Lenape, and the colonists were afraid that they were going to side with the British, so they massacred them. And they did it in some of the most violent fashion you can imagine, including clubbing them to death, dragging people who were still alive with the men, women, and children into their council building, and then setting it on fire to burn them alive. That's what the colonists did. So when I hear anybody suggest that we represent somehow an undistinguished destruction of all ages, sexes, and conditions, I got to go right to the beginning when they're basically saying this. And of course, as you well know, the United States has continued this legacy of undistinguished destruction. I mean, they dropped 2 atomic bombs on a small island country that was already facing defeat, and they dropped it on civilian populations: men, women, children, old men, old women, children. I mean, they did this in the 40s. And if we could just say, okay, yeah, you're talking about the 1700s, and now you're talking about the 1940s. 3 weeks ago, what they do? They bombed Iran, and they basically bombed a school, killing 170 schoolgirls. So, I'm sorry, the offensive nature of the United States calling us, these colonists calling us these merciless Indian savages. This is the truth that I think has to be talked about, and I'm not even getting into the other charges, but that's part of the reason that I do the work that I do, and it's clear that's why you're doing the work that you're doing. Talk to me about about going to Atlanta and how you believe the counter narrative, which apparently isn't. It's not just about us. I mean, from what I understand, the emphasis in Atlanta is to push back on genocide more broadly. And I'm glad that you're going there because, honestly, in the world that we live in, we are not getting very high billing in the talk about genocide, even though we are victims of the longest running continuous genocide because it's still going on. But because they're not blowing up our children, we're not getting the headlines on CNN and in the mainstream media. And so the focus is on Ukraine. The focus is on Gaza. The focus is on Iran. And I'm not saying that those things aren't horrific, but if you don't understand that this isn't just about Donald Trump, this isn't just about the current state of things with the United States. This has been the longest running history that of aggression that has ever existed. So again, talk to me more about Atlanta.
Well, I'm really excited about actually heading to Atlanta to meet with other like-minded folks. We are working with Black, Brown, and Indigenous relatives on this effort for this anniversary event. But I want to go back to what you're saying and about the history of the narrative, right? And I think we're at a really critical time because, you know, people don't read documents, right? They don't read the historical documents. I think that we are at a war with technology itself, a war that we're battling even with our own youth. And so, believe it or not, I was around during the time before the internet existed, right? And so most of the information that we got, came from people sharing information, usually by documentation, and that, wasn't easy to come by. Now we live in a time where we have, unlimited resources for gathering information, and also we're living in a time where we have social media where we're able to even document a lot of the injustices that are happening ourselves, right? Even though we're starting to see more now censorship around that, we had a really good run where we were using technology to our benefit, where we were able to share stories across our struggles, not just our with our Black relatives, and but also with our Indigenous relatives across the world. And we got to see the commonalities between the oppression that we are experiencing, and really tie the colonial link there, if you will, through the doctrine of discovery, which I'm sure we'll talk about a little bit more. Um, but I think we're at a really critical time because even though this information is so readily accessible, we have two things. We have, the way that these tech companies are trying to manipulate our young people and distracting them, right, through these different social media platforms, and really kind of moving them away from understanding history or using these tools for education, right? And then um, we also are battling with the manipulation of the social media now with this new administration, and trying, even we're seeing blatantly how this administration is trying to rewrite and erase the history, right? And we know that they have taken down documentation, and they're trying to manipulate what's in the historical museums in terms of slavery and genocide and all of the atrocities that have been caused. And so this event is really a way to engage, or I should say re-engage some of our community, but also engage a lot of the youth, because in the work that we do, historical context is so important. We have to know where we've been, what our ancestors what their struggles were in order to get us to this place that we're at now, so that we go in, with this, doing this work. And it's hard to call it work, right? Because it's really just protecting our existence and our livelihood. But
Can I
doing
can
this,
I can I jump in just for a second, because I want to go back to
yeah,
what you were talking about with the access of information, because one of the problems is that the entire world is inundated with information, and some of it accurate, some of it not so accurate. So even though there are voices like yours and mine that are out there, we are a small peep compared to what people are being inundated with. And of course, the internet is sexualized, it's sensationalized. Of course, now you got AI that creates images that you don't even know if are true. I mean, they certainly aren't even true. So we still remain, even with our access to technology, we remain at a huge disadvantage. And many of our people have adopted certain elements of of their narrative, and have tried to incorporate it in ours in such a way that it kind of undermines much of what we're talking about. I mean, and so let me jump a little bit to the side here. We just had a ruling this week by this, or we didn't, but they had a ruling by the Supreme Court on birthright citizenship. And for all of the conversation about birthright citizenship, we still aren't really being fully included in that conversation in the way that it should be. Because let's be clear, the 14th Amendment didn't include us. And it didn't include us. It wasn't a slight, it was an acknowledgement that we weren't them. that we weren't a part of, and we weren't a part of their Constitution originally, and we sure weren't a part of it in the 14th Amendment, which was, which comes almost, 100 years later. So I've talked about this at length. They amended their constitution, which is a pretty high standard. I mean, to amend your constitution is a much greater standard than some joint resolution of Congress or even Congress passing a statute. So they do this in 1868, and they knew that a constitutional amendment was required to fully engage, and the target obviously were the formerly enslaved, but in the language of the 14th Amendment, they basically say all persons born or naturalized within the United States and subject to the jurisdiction thereof are citizens. Now, the crazy part is they don't say are entitled to citizenship. They just say you are a citizen. So it's kind of, in many ways, it's kind of imposed even in the 14th Amendment. But again, that's a constitutional amendment. And they knew they had limits within the constitutionality. So that's why they did exclude us. They excluded us because they had no constitutional authority to include us. I mean, and that's my point. Because when they say subject to the jurisdiction thereof, they know that in 1868 they clearly didn't have jurisdiction over us, and they made some distinction, because in the second section of the 14th Amendment, which is the apportionment clause for representation, they try to fix their 3/5 compromise relating to whether how black people will be enumerated for representation. So they basically say they count all persons, excluding Indians not taxed. So if there was any question about subject to the jurisdiction thereof, whether that excluded us or not, the second section makes it very, very clear. So we weren't included. And again, it's not because of a slight, and it isn't because of it's not even necessarily because they recognize all the sovereign nations of Native peoples. They just know that we weren't included with them. And they go back 100 years. They referred to us as Indians not taxed in the apportionment clause, the original apportionment clause of the Constitution. They actually equated us more with foreign nations when it came to things like the Commerce Clause and even the Treaty Clause, because clearly the United States entered into treaties with our people. I think most of them were an attempt at fraud on their part, but they still engaged us in that treaty-making process, which was formalized in their Constitution. And you can only have treaties with people who are not of your own citizenry. So that's an issue. So, and the reason I'm dragging all this stuff out is because I've heard some people talk about, well, they did mention, this. And in fact, if you recall, the executive order and then the defense that the Trump used for getting rid of birthright citizenship, he cited a Native case. I don't know if you're aware of that, but he cited a Native person who was arguing that he was entitled to birthright citizenship. And this is before 1924, and I'll get to that exactly in a minute. And he wasn't, because, again, Native people were excluded from birthright citizenship, and we're still excluded constitutionally from birthright citizenship. But I heard a few people, including a lawyer, who basically said, but they took care of that when they granted us citizenship in 1924. Again, let me be clear. They didn't grant us citizenship. They declared, and Congress did this. They did it statutorily. They didn't do it through a constitutional amendment. They passed a law and just declared that we were citizens. They didn't ask us. They didn't create a process. There was no treaty. There was no annexation. There was no pledge of allegiance or oath that we had to take. No, they just said flat out, you're all citizens now. And of course, the question that I have to ask is, well, didn't we have a say in the matter? So, and you and I talked, that my position is I'm not a U.S. citizen. I'm Gunyagahaga. I'm Mohawk. I'm Ongwe Ungwe is our word. That is who I am. Now, I don't hate Americans. I don't hate U.S. citizens. I don't have any kind of loathing, sentiment towards them. I'm just not them, and I reject the notion that they can just impose their citizenship on. And the question that I have, and I haven't gotten a lawyer to answer this question: does Congress have the authority to impose citizenship on anybody, or is it only that they've adopted this authority to us through the, you and I, we're going to talk about the doctrine of discovery, but the other two doctrines that I am passionately opposed to is the trust doctrine, where they've treated us, where they've cast us as wards of the federal government, and the plenary powers doctrine. The Indian Citizenship Act of 1924 is really only legal within the context of the plenary powers doctrine. And that plenary powers doctrine says that Congress has absolute authority to do whatever they need to do, whatever they want to do, to us, for us, against us. And we don't seem to oppose that, because there's a certain element within native territories and of course in the legal community, among legal scholars, that suggests that the plenary powers doctrine offers us a level of protection against state tyranny. Well, I think you can only accept that if you ignore all the things that the federal government has done to us, including giving states authority over us with things like, their public laws. And in New York State, they have US 232 and 233, which grants New York State criminal and civil jurisdiction. That's the federal government handing off. In fact, the Indian Gaming Regulatory Act. I mean, just look at that. The federal government, the Supreme Court ruled that states didn't have the authority to impose their will on us over gaming. And so the federal government passes IGRA, the Indian Gaming Regulatory Act, and the first requirement of IGRA is to say you must have a compact and grant certain regulatory authority to the states. So the first thing they do is hand it off to the states. So I am vehemently opposed to the plenary powers doctrine, the trust doctrine, and of course the doctrine of Christian discovery. And we can talk more about that. But I had to get my rant out, so I apologize. But I'm interested in what your thoughts are on everything I just said.
Oh my gosh, there's so much there. Where do we begin? But yes, absolutely. And I think that it all, as again, going back to the doctrine of discovery, where all of this really kind of began, when first of all, of course, it took our lands, right? It was terra nullius. Our lands were empty, according to them, of any Christian people, which really is our connection, right? That is our connection to our Creator, is through our land. That is our Creator. And so taking that from us, the colonization just kind of evolved into our own people and our own minds to this day, not recognizing the trickery that happened behind it, right? To the point where we're trying to protect ourselves by saying we're U.S. citizens because it provides us more protections, while not understanding the harm we're causing by saying those things is diminishing our sovereignty as sovereign nations, right?
Well, I mean, how can you be sovereign if you're a U.S. citizen? I mean, it doesn't even make sense. I mean, I would go a step farther, Eve. I mean, think about this. If we accept U.S. citizenship, do any of the treaties really exist anymore? Because a country cannot have a treaty with its own citizenry. And nobody even addresses that. I think I'm the only person who's ever raised that specific point. And it doesn't get a whole lot of airplay, because I think that's one of the things that our own people are afraid to fully address. I mean, and I think that is what is so problematic. And the doctrine of discovery, one of the things that I talk about in our film, which I sent you, I don't know if you got a chance to take a look at it, but it's called The Long Hope. One of the things that I talk about is that the longest serving Chief Justice of the Supreme Court, which created all three of these doctrines in U.S. law, doctrine of discovery, he codified that, the trust doctrine, the plenary powers doctrine. In his ruling in Johnson v. McIntosh, where they codified the doctrine of discovery into U.S. law, he said, however extravagant the pretension is of converting discovery of an inhabited country into conquest, if you can do it, if you can get away with it, if you can sustain it, and you can build upon it, then essentially what he said was the lie becomes truth. Because it's not an extravagant pretension. It is a bold-faced lie. I mean, you cannot suggest that by laying your Christian eyes upon a people and a land, you not only can claim the land, but you can claim to have conquered the people. And this is, and this is what we battle, right? I mean, the narrative is always that we are a conquered people. Well, if you're suggesting that merely looking at us through your Christian lens is equated to conquest, well, I'm sorry, that's not true. And so I think what gets lost, and you mentioned earlier, we don't read a whole lot of documents. Like I said, nobody's read this doctrine the Declaration of Independence. They've never looked at the hypocrisy, even of the preamble of it. But when you get into the minutia of the legal analysis and the legal foundation that they establish by codifying the doctrine of discovery, creating the trust doctrine, casting us as wards, incompetence, which that need oversight, with the United States claiming to be our trustees without any trust agreement. I mean, there's no legal document that says that. They just say it. And then of course the plenary powers doctrine. This is the part that concerns me, because even much of the work at the UN, I mean, including the recent Permanent Forum on Indigenous Issues, I don't think there's a strong enough emphasis on going after all three of these legal doctrines. Because let's be clear, the UN DRIP says all doctrines, policies, and practices that are based on superiority of a peoples, are racist, scientifically false, legally invalid, morally condemnable, socially unjust. That's what the UN DRIP says. Unfortunately, it doesn't go quite, by saying it's legally invalid does not necessarily say that it's illegal or that it's criminal. But I think that's the next step. And I think that's the conversations that need to be happening in these international forums, like the UN, like the Organization of American States. We've got to call it out for what it really is, because these principles, which they still insist are settled law, are legally invalid. And on a final note on this rant, we can't seem to get the liberal justices to even weigh in on this stuff. At this point, Clarence Thomas has questioned the plenary powers doctrine. Sam Alito has raised some questions about it, and even Neil Gorsuch has done it. I think for other reasons. I think part of it is about enhancing states' rights over us, but their questions about the legitimacy and the constitutionality of plenary powers being granted to Congress they're valid arguments. And frankly, the same arguments would apply to them trying to suggest the states have power. But where's Kagan, Sotomayor, and Jackson on this? Why aren't they? Because we already know Ruth Bader Ginsburg actually cited the doctrine of discovery in 2005. So, I mean, this is problematic. And while I recognize that court is not our court, they still have a responsibility to make sure. I mean, look, the court's only function, really, the court's only function is to determine the constitutionality of their legal framework. And there's no constitutionality with this legal framework.
Absolutely. And it was definitely, this framework was not made in our favor. It was made to protect the states, which is why they create laws that overlap, right? They overlap in order to continue the oppression. And what you're saying about the UN is really important. That's the whole reason why our relatives went to the League of Nations in the first place, was because they knew that we could not fight our battles within the domestic arena. We cannot fight a colonizer who is the judge, juror, and executioner. And so the whole reason why we went to the UN in the first place is to ensure that the treaties were put into international law and recognize international law, which is what we are still fighting to do today, because 40, 50, 60 years later, that still hasn't happened.
Well, and on that note, let me just say, look, if the United States is going to violate the treaties, and they clearly have, almost all of them, then what we need the international community to really assess is what is reverting back to the conditions before the treaties were signed, because most of those treaties were not signed in our favor. We didn't negotiate them. We didn't articulate them. They wanted these things. So, and most of the time, in fact, in Mohawk, we have a word for a treaty that translates to "we give up our lands to maintain peace." I mean, which is kind of a sad note, to even suggest that. But so my point is, U.S., if you're gonna violate the treaties, then let's go back to the time before the treaties. Let's return the land. Let's resolve it properly, because you can't, if you have a contract with somebody and you violate the contract, you don't get to keep everything you got from the contract. You have to compensate and return, the ill-gotten goods. And that's essentially what the United States has done. But so I say that while I want to defend our position on treaties, I'm also somewhat hesitant to be too much dependent on those treaties that were crafted and drafted by them, not us, because they oftentimes, under the canons of construction, and the U.S. Supreme Court has suggested that if there's ambiguity in a treaty, that they must be interpreted in our favor. That's what they say. But they don't do that. I mean, so even though the Supreme Court has said something like something logical like that, and of course the reasoning was that their language and their legal frameworks associated with treaties and contracts and stuff like that, that's their purview. If they can't be clear and unambiguous, and if there's any way that what they're saying to us could be interpreted differently, then what the courts basically have said, you have to interpret it through the lens of Native people. But unfortunately, that's not the case.
Right. And I don't disagree with you, but I will say this, that there is one important point about the treaties that I think a lot of people tend to overlook. It's not the fact of what's written in the treaty. Of course, that's absolutely important. But the fact that these colonial governments created treaties, it's a symbol of recognition of our sovereignty and a symbol of recognition that of our inherent rights to our territories and lands. And that's why the treaties are so important, because they are constantly trying to diminish our sovereignty, right? They put in tribal governments that mirror U.S. governments and try to do away with traditional systems of governance, which we know, is what supposedly the U.S. was trying to do, right, through the Haudenosaunee Confederacy. And every time I talk to my Haudenosaunee relatives, they always say they got it wrong because they did not include the women as the leaders, because that's the way it traditionally was. But the purpose of why we bring those treaties forward is because it is that recognition. It's the very foundation of recognition that they had an agreement with us, because they recognize that these lands and territories belong to us as indigenous sovereign nations, separate from them as another nation. And so having those treaties in the international court and international arena is super important. The forums that we attend, I've been attending the Permanent Forum on Indigenous Issues for the last 15, 20 years. And I can tell you that the international work is really difficult, because it's not meant really to help us unless it doesn't have any legal teeth. There are certain mechanisms that we can utilize to kind of advance some of the rights and put some protections up. But in order for us to really have any kind of legal standing and within that system, is we have to be able to assert our treaties to bring forward that recognition, that we are in fact sovereign states and sovereign nations, based on these colonial governments acknowledging that we are in fact sovereign states and sovereign.
Well, and the irony is that we had treaties with the predecessors of the United States too. I mean, and I think that's what gets glossed over. And of course, the question remains, and I raised this in our film. We have treaty after treaty after treaty, and there may be as many as a dozen treaties early on in with the birth of the United States, where there's a full acknowledgement that we own our lands. In fact, the Canandaigua Treaty, which has problems, but 3 places in the Canandaigua Treaty, it acknowledges, the United States acknowledges that our land is ours, that the property is ours, and they will never claim the same, nor will they disturb us in the free use and enjoyment of that land. It's said 3 times in that treaty. That's 1794. Yet in 1823, Chief Justice John Marshall says we don't have title to our lands. He flat out says, and this is the codification of the doctrine of Christian discovery, that we merely had a right of occupancy. And that right of occupancy isn't really a right, because they can extinguish it at any time. And the courts, one of the things that I mentioned in the film, the same court that could recognize racism in Brown versus the Board of Education in 1955 or thereabouts, they had a ruling against the Tlingit in Teton territory, where they basically said No, you don't. You can't sue us for the taking of timber off your lands because you merely have a right of occupancy, and we can extinguish that right of occupancy and the right to any of the resources on the lands that you occupy without compensation. So the same crew, the same judges who could recognize racism in education could not recognize the racism, the overt racism associated with the doctrine of Christian discovery. And these are the
Absolutely.
truths that are so important that we get out there. And whatever frustration that we have at in these international forums like the UN, we just have to hold them responsible for their own language. Like I said, scientific or racist, scientifically false, legally invalid, morally condemnable, and socially unjust. That's what they said, not what we said. That's what they said.
Yeah, absolutely. As a matter of fact, we have a campaign currently within our movement in the North and the South in our international community to put forward our own nominee for the Secretary General of the United Nations this year as an Indigenous woman as a nominee, because we want to, they recognize, according to the declarations, they recognize our right to self-determination, yet they don't want to give us an equal seat at the table. That's always been the issue. And even it becomes very problematic because you also have, areas within the work where they offer us, a seat at the table. This was something that they entertained years ago when we were demanding to have observer status at the very minimum, right?
Mhm.
As sovereign nations, and they said, well, maybe we can give you one seat at the table to represent Indigenous peoples, and it's like, how many Indigenous peoples are there around the world, and who is going to represent just one, that one seat, when we all have such different ways of living, and something that applies to one may not apply to another. So that ended up causing a lot of infighting amongst ourselves, and I
Well,
think
yeah,
that
who gets to choose? Who gets to choose the person? I
who
mean,
gets
they're just
to
the
choose.
basic bottom line. I mean, and I
Absolutely. And
know,
the youth
I
continues to be utilized that tactic against us.
I know, just having talked to you briefly, and I know the work that I do. You and I are more like outliers, honestly, and as unfortunate as that is, and I don't think anything that we're saying is some should be regarded as fringe. I think what we're saying is really well documented positions against some of the policies and practices of the United States. So the fact that there are those who are opposed to fleshing out and trying to eradicate the doctrine of discovery, the trust doctrine, and the plenary powers doctrine. I think that there has to be more meaningful conversations. And look, I know the work that you do, and all I'm saying is that as you do this work and you host panels and discussions on this stuff, and you do this stuff not only in your home territory, but obviously you're well equipped to travel. Um, Man, I'd be open to an invitation to participate in any of that stuff because I don't think voices like mine are breaking through, and I think there are people who can come across as maybe kinder and gentler than myself, but I don't think anything I'm saying is terribly vitriolic. I think what I'm saying is just truth.
Absolutely. And it's important. It's important for those voices like ours to be heard. And that is the importance of having these gatherings and these discussions, is to engage others, because we are also at a pivotal moment. We've been fighting against colonization for over 500 years, but now we're starting to see that I mean, not us as Indigenous peoples, but our non-Indigenous relatives are starting to see the oppression affecting them as well. And now they're starting to stand up, not because we've been doing it for 500 years, but because now it's affecting them and their livelihoods.
The chickens
We
have
are
come
not
come home to roost, as they say.
Absolutely. We're not the only ones being targeted here anymore. And so it is important to have these discussions because, and I will say this, we recently had a summit on the doctrine of discovery in Mexico City. And there is a disconnect between the understanding of what the doctrine is and how we got to where we are, and really community folks that are feeling the effects without without even understanding that the root cause of it is the doctrine of discovery. So in that summit, we're talking to community members about our plan on the international level on how to dismantle the doctrine of discovery. And they're looking at us like, but our lands are being taken right now and our water is being contaminated. Why aren't we talking about those things? And the thing is we are talking about those things because I mean, you know, there are some of us that can't do all of it, but there are people that we have to work together. We have to continue to keep fighting and pushing back against the immediate threat that's happening right now, right? But we also need to go to the root cause of these issues because we cannot live in a movement and in a system where we're just constantly putting band-aids over all of these issues that we're having.
And that's my point, because if we don't address the root cause, I mean, look, we could talk about missing and murdered Indigenous women. We can talk about poverty. We can talk about, you know, even certain, you know, assimilation policies and the, you know, the federal recognition. I call it Fed Rec, the Fed Rec process. We can talk about all that stuff, but all of that is tied. Look, even the defense of the Indian Child Welfare Act, I had a problem with the law in the first place because the law has a lot of flowery language in it, but it never fully recognized our authority over our own families. It was still federal guardrails being put on the states to say, well, if you're going to place a Native child, you got to place them in a Native home. But they didn't really fully defer to Native courts or Native leadership or Native organizations to determine whether a child should be removed from a household and where they should be placed. It was still between the state, the feds and the state. And the only defense against the Brackeen challenge was plenary powers. They never said, well, it is, as the Brackeens suggested, that it was racist, it was discriminatory, violated the Equal Protection Clause of the 14th Amendment and all that other stuff. The courts never addressed any of that. They never said, well, for one thing, Native people weren't included in the 14th Amendment. So there were distinct, autonomous political entities. We aren't merely a race of Americans. And the courts won't say that. Instead, they say, well, Congress can pass any law they want regarding Native people, and you have no standing to challenge it. In fact, arguably, no one has standing to challenge the plenary powers doctrine, because if you look at the history of that legal doctrine, the courts have consistently said that power is beyond judicial review. Well, how could any power within the United States be beyond judicial review or constitutional analysis? I mean, and that's where we're at. So I agree with you completely. And I'm so glad I'm glad to have met you, first off, and I'm glad that you know, my friend Bob Lederer suggested that we connect, and I'm hoping that we can do more, because I think the work that you're doing, and geographically, I live amongst the Haudenosaunee. I am Haudenosaunee, and you're doing work in the Southwest, and I think we have to build those bridges, and I think the conversations that we're having have to be sustained and expanded.
Absolutely. And the same goes for international law, going back to the recognition. I mean, you know, most people are surprised to find out that Indigenous peoples weren't even considered peoples until 2009, when the UN Declaration passed. I mean, we were just seen as populations. And now, currently, they're trying to even lump us into Indigenous peoples and local communities, which is trying to diminish our inherent rights. And the same thing goes with the CEDAW, the Committee on the Elimination of Discrimination Against Women. I had no idea myself, working in international arena for 15, 20 years. I had no idea that complete mechanism did not include Indigenous women. And recently, in the last couple of years, did they pass the Article number 39, which specifically includes Indigenous women in that. So here I am, you know, thinking, oh, Indigenous women, or, you know, women, including Indigenous women, have these international protections through this CEDAW mechanism. And then I come to find, well, no, wait a minute. What do you mean it didn't include us as Indigenous women throughout this. I
Yeah.
mean, this is literally a couple of years ago. And so, again, it goes back to educating people and educating community and really having that historical context. Unfortunately, the tactic that the colonizer uses is working, where they are throwing so many situational bullets at us that it's so difficult for us to even come up and grasp air
Well,
and
and
try
you
and
you make
figure
a
it
good
out.
point. There's a lot of wordplay, going on here. I mean, honestly, you do have to go back to 2005 to see one of the Supreme Court justices specifically refer to the doctrine of discovery. See, what they do now is they defer to the case that codified it, which is Johnson v.
Right.
McIntosh, and they do it today. I mean, this isn't stuff
Absolutely.
from 20 years ago or 50 years ago or 100 years ago. They are still, and they use that Johnson v. McIntosh case not just to make rulings relating to land title, but to jurisdiction. So that's where we come back to, right? I mean, so if we don't address this, and look, I think it's fine. It's great to take trips to Rome and get the Pope to say certain things, but let's be honest, the Pope didn't fully he repudiated the doctrine of discovery, but he didn't rescind it. And the difference there is by repudiation, the Pope at the time, and it's not even Leo, it's the one before him, what they said was that it was a misinterpretation. It was the Christian monarchs of Europe that created the doctrine of discovery, not the church, not the papal bulls of the Vatican, which is essentially, it's not just dishonest, it's a lie. I mean, there's no question, and it wasn't even created specifically initially relating to us as indigenous people in this hemisphere. It was to go after Western Africa. It was the first papal bull that basically talks about all Saracens, pagans and other enemies of Christ, that they can be enslaved and their stuff can be taken. It was about Portugal going into Western Africa. So,
Okay.
and that's
Yep.
the
They were
church
sick.
doing that stuff. So, while it's great to have a repudiation, it doesn't really hold up in U.S. law. I mean, because it's funny, the United States will use these international uh, dogmas, I guess, when it's convenient to them. But then they'll reject the UN Declaration on the Rights of Indigenous People, say it has no force of law. They'll reject the church's repudiation of the doctrine of discovery. But the fact is that the United States relied on that to create the myth that they could claim all of our lands, and I find it not just problematic, but I find it disingenuous. I have no interest in going to Rome. I mean, the problems that I have nothing to do with the Catholic Church anymore. I mean, it did. I mean, when they were operating boarding schools and their church dogma was being put into law. But now it's with the United States, and the international community has to step up, and they have to hold the United States accountable for doing something that they have fully acknowledged is legally invalid.
Absolutely. And that's why having these gatherings on the doctrine of discovery is really important, because it's a way to educate people on the history and how we got to where we are. And again, I mean, I know a lot of people talk like, oh, well, that happened so long ago, and this doctrine was from the 1400s. How does it affect us today? And that was the past. We need to move on and look to the future. But they don't recognize that it's still being used in U.S. law today against our people, just like you mentioned the court cases. They continually go back to that Johnson v. McIntosh case in order to continue to knock down and assert their dominance over us and our territories and our lands and our inherent right to those lands. And so, yeah, absolutely, it is important for us to get community educated on these doctrines, to understand that that's the root cause of all of the colonization and oppression that we're experiencing now, because we have to be able to go back and say, how did we get to where we're at? It's almost like a web that we have to kind of find the string and go back to the beginning to find out where to untie that knot in order to really make progress in the work that we're doing. And
Well, and
so, but
my point to the United States is that, yeah, we should understand where the stuff originates from. But the more important thing is, when did they violate their own laws to incorporate these sentiments? When did they violate? I mean, so in 1823 with Johnson v. McIntosh, what a power did Chief Justice John Marshall have to undermine every treaty that was signed before his ruling, and suggest that we didn't really own the property that we occupied. I mean, how could he even dare say that? And then the United States would continue to negotiate treaties for another 50 years afterwards. So it's not like,
Exactly.
he said all treaties are invalid. He didn't actually say that. So this
No.
is the issue, and I think, again, for me, I can't get past the notion that a country could designate a people based purely on their existence predating their own as wards of the federal government. I mean, is there anything more racist than to say you are incompetent and you are not capable of managing your own affairs, so we're going to cast you as a ward of the federal government. We're going to place ourselves as your trustee, and we're going to determine loosely what benefits you. But they've made it very clear in this whole trust doctrine that the primary beneficiary of the trust relationship is the United States, and they admit it. I mean, Sam Alito has done the work and actually has called it out and said, look, the whole formation of this trust relationship was to ensure the national interest, not and loosely, be concerned about the welfare of Native people. I mean, how does that even exist? And then, of course, again with the plenary powers, how can Congress have been granted ultimate and unchecked authority over us? And again, with all three of these doctrines, only Native people are impacted by this. And internationally, other countries have followed suit, but in the United States, and it's not to undermine or to negate the oppression that Black people and other immigrant populations have experienced, but nobody has laws this concretely set against them the way Native people have. So I wanted to close my thoughts on that. We're about out of time, so please offer your final thoughts on not just on the weekend, but the work that you're doing, and hopefully what we can do together going forward.
Absolutely. I think these conversations need to happen. They're really important. And I know a lot of people don't have an understanding of these doctrines. And I really encourage folks to look for that information. And I'm working with our relatives in Aotearoa, our Maori relatives, who are working on curriculum that is specific for youth to educate them on the doctrine of discovery. And I think that is where we have to focus, is with our youth, because our elders who are no longer with us, who have passed that knowledge on to us, it's our responsibility to carry that on, to uplift their legacy for our collective liberation. That is the whole idea. And I think that it's going to be uncomfortable. It's going to be uncomfortable for a lot of people, not just non-Native people, but Native people alike, because, we are a colonized people, as evidenced by us speaking English to each other, right? We have to admit that, and we have to get more uncomfortable with being uncomfortable. And I think these conversations are a part of that. And that is really what it comes down to, is having these conversations, making it uncomfortable, because we also have to admit we have a lot of our Indigenous relatives who are also Christian, and that becomes a big issue, a point of contention when we start talking about the doctrine. But we have to have these honest conversations so we know where we're at, we know how we got to where we're going, to where we are, and so that we can know how we can go where we need to go moving forward. But definitely I welcome us continuing these conversations. I just wanted to share, we do have a summit coming up in New Zealand, in Aotearoa, on the doctrine of discovery in October. And we are also doing a Doctrine of Discovery workshop in Western Shoshone Territory at their treaty conference in September. So these conversations have to keep happening. I encourage those who have that knowledge and background doing that work to engage with community and educate them, because our historical context matters. I can't say that enough.
Well, Eve Reyes-Aguirre, I want to again thank you for joining me on the program. I look forward to having you back. Maybe we'll catch up after the Atlanta stuff, or maybe when you get back from New Zealand, and we can kind of assess what was accomplished and the work that needs to be done going forward. Again, I want to thank you. I look forward to having more conversations with you, and again, I thank you for joining me on the program.
Thank you for having me.
All right, folks. Well, I'm John Kane, and this is Resistance Radio, and you heard it here. So I want to thank you for listening, and I want to again thank my guests for joining me. We'll be back next week. Hey, don't get hurt with all the fireworks and all the celebration that you're going to be you're going to have to experience one way or another this weekend. Be careful and stay safe. I want to thank you all. Yahweh.